231-500-139. Counsel for the state and for the defendant are present. The defendant is present as well. Sure. Just need to not spill it. Okay. Lots to cover. Ms. Nestor, I appreciate the email you sent earlier this morning. Should we start with the O'Driscoll interview?
Okay.
Does that make sense?
Yes, sir.
Okay. So this is docket 1163, which is the state's motion regarding portions of the O'Driscoll interview as clarified by docket 1555 and Ms. Nestor's email of this morning. Let me get there with you. And I left both of those items on my printer. I'll be right back. You can stay seated. Thank you. Have a seat. Thank you. Okay, Ms. Nestor, with respect to pages 1 to 7, what's the value in, or I guess more accurately, under Rule 106, how do pages 107 qualify, explain, or place into context the stuff that follows?
Mainly because he gives the reason why the whole interview is happening, like what he's doing there and why the interview is happening, and from his perspective. And I believe that's important to put the whole interview into context. I don't see there's anything at all objectionable in it. And it does provide a context of how this meeting happened. They're not in the police station, they're in her house. She invited him in. She voluntarily met with him. All of that, I think, matters to context, and we're asking that it come in, especially because there's nothing in it that's controversial, and there are things that I think that are very helpful.
Mr. Bloodworth.
Your Honor, there's a distinction between context to the interview and context to particular statements. And while this provides context to the interview, it provides no context to kind of any of the 6 individual statements. The interview context can be sufficiently drawn out through examination of Jeff O'Driscoll. I mean, I'll lay a lot of some of that foundation before I introduce any of the statements, and then of course he's subject to cross on that. The other thing is this is peppered with the defendant's self-serving statements. that the state holds the keys to.
Okay. So we're going to do this one chunk at a time. The standard under Rule 106, and it's not discretionary, it's an on or off switch, is whether the portions that, in this case, the defendant wants to add to the designations made by the state are necessary to qualify, explain, or place into context the portions of the interview transcript that the state seeks to introduce. That's under cases like State versus Cruz Meza, 2003, Utah 33, at paragraph 14. Here, with respect to pages 1 through 7, I'm persuaded by the state that this context for how the interview occurred will come out through direct and cross-examination of Detective O'Driscoll. These 7 pages are not necessary to qualify, explain, or place into context any of Kouri Richins' statements that follow. Okay, so we're not going to add 1 through 7. Those will stay redacted. Then we get to pages 15 to 16, right, Ms. Nestor?
Yes, sir.
Okay. This is new as of this morning. Give me just a moment. Did you have a specific line number or the whole pages?
Just the redactions that are on both pages, we would like unredacted. So it starts at line 10.
There are no redactions on those pages.
I have redactions on lines 10 through 25 on page 15 and lines 1 through 12 on 16 is the copy I was given.
Your Honor, in negotiating this back in whatever, January, the state conceded to her request to unredact that. The state unredacted it. The current copies, which are before the court, and then the link I recirculated this morning, show no redactions there.
Okay. That's moot then.
Very good. That brings us to pages 29 to 32. So here we have Ms. Richins making references to Eric going to jail and Cody's involvement in that situation. Ms. Nestor, why is this necessary to qualify, explain, or place into context Ms. Richins' statements in other parts of the transcript?
Give me just 1 second, Your Honor.
Sure.
So previously, they were talking about whether or not Eric was happy, if he was depressed, if he was suicidal. And as a flow, an arc of that conversation, she then goes into the question O'Driscoll asks is, okay, anything else regarding his mental health history? That's line 3 on page 29. She answers, no, not really. But then she goes into like, there wasn't generally, he had his struggles, he was stressed. And then she explains how he was stressed. So I think or why he was stressed about his relationship with his business partner. I do think that completes the answer to the question. It completes the entire subject matter of the conversation. It's actually evidence that has already come in as far as no longer being objectionable. This all came in Cody's testimony. So we would ask that it be put back in.
So I think you have fairly characterized everything through page 31, line 3. After that, though, I think he turns in a different direction. That is not relevant or does not qualify, explain, or provide context for what you just described.
I really don't care about the rest of it.
Mr. Bloodworth, line 29, page 29, line 5 through page 31, line 3.
So we will unredact that portion. Your Honor.
I think it's a fair continuation
Fair.
of Kouri's explanation regarding things that were stressing Eric Richins.
Yes.
Okay, very good. So we're going to unredact page 29, line 5 through 31, line 3. The remainder of that redaction stays as is. All right, I think then we go to pages 107 to 112. Help me out, Ms. Nestor. I wasn't quite following defendant's position on this.
Okay, just 1 second, Your Honor, I'm sorry. So this, and it's getting hard for me to remember what I know from what happened in the courtroom versus what I know from getting ready for trial, so I apologize. I cannot remember if this came in yet. I think it's going to come in with Mr. O'Driscoll if it hasn't already with Chelsea, but there's conversations in here about texts with Chelsea on the day that Eric passed. And it's a continuation of O'Driscoll asking about phone records and him reviewing available phone records. And she goes into what she's reviewed in terms of the calls between her and Chelsea. So I do think it's all part of one conversation. Let's see. And I think to the extent that hasn't come in yet, I think it's going to come in today.
Well, I don't disagree with your prediction about what Detective O'Driscoll might testify to. The task I have to engage with here is whether any portion of 107 through 112, line 9, is necessary to qualify, explain, or place into context Ms. Richins' other statements in this interview.
So I think it's a direct continuation of the questioning above it about telephone records and whether
Right.
she has available phone records, and she discusses these records of calls with Chelsea. So I do think it's all one conversation.
Can you point me to specifically? It seems to me that in the preceding pages they're talking about what phones she had access to during what periods of time, when those devices were or were not available to her, which belonged to C&E, which belonged to her.
If you go back just a little further, Your Honor, to page 105, line 15, Detective O'Driscoll starts with, okay, so when was the last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation, which to us is misleading, and we'd like it all in.
Your Honor, may I offer a suggestion?
Yeah.
The state proposes to redact page 105 line 15 all the way down through 107, line 11. So redact the entire portion as it relates to Chelsea Barney.
That removes the necessity of what follows, Ms. Richins. Oh, sorry, Ms. Nestor.
It does, except that I think they'd have to go back further because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this, it would eliminate my objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at that.
The state still gets the general question on page 104 into 105. It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, yeah.
For example, just so the record is clear, because we only have an audio record here,
Sure.
we have Detective O'Driscoll asking about whether is it possible that things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right. Right. And then he gets into Chelsea starting on page 105. So, right. If they would delete from 3 of 105 all through all of it, then that eliminates my objection because then they're not just putting in half of it and not the other half. But I would withdraw my objection under those circumstances. But if they want half of it in, I want all of it in.
Well, okay, Your Honor, I think we're narrowing in on this, but I don't think we're there yet.
Okay.
I think the defendant raises Chelsea, right, at page 105, line 8. It wasn't Detective O'Driscoll. So I think the redactions should begin
Oh, I see your point.
at
Line 15. She's using recovery of information on Chelsea's phone as an explanation for why she wouldn't bother to delete anything.
Correct.
Okay.
And I think
So-
there's a distinction between, right here, I think at line 15 is the tipping point where there is a statement about deletions.
Right.
And then at line 15, it tips into a discussion about text messages with Chelsea in particular.
That's fine, Your Honor, if you want to start at line 15.
Okay, so we will add the following redactions. We will redact line 105, page 105, line 15 through 107, line 11. And that resolves defendant's request to unredact pages 107 through 112, line 9. Scott, I went kind of fast there. Did you get that?
Yes, Your Honor. We have someone else listening in.
Okay, very good. All right. Anything further on that, Mr. Bloodworth?
No, sir.
All right. $15 through 107, line 11. All right. That brings us to page 120. Line 24. To 121, line 8. This is Kouri Richins giving Chelsea's phone number to Detective O'Driscoll. I didn't follow how this relates to a prior statement.
Just 1 second, Your Honor, I'm sorry. So all this stuff above that is redacted, right? Are you looking at it?
Yeah.
Just a minute, I'm trying to. Twenty-four through line 121, line 8. I'm sorry, I'm getting a little bit lost. Just give me, let me
No
look
problem.
let me look at my notes that I did just one more time. So right now we're looking at the 120, line 24 through 121, line 8.
Please.
Okay, I got it. Just one second. This may not apply anymore now that Chelsea's testified, but let me just make sure. We'll withdraw that one, Your Honor.
Okay. Then let's go to page 125, lines 6 through 16. I genuinely don't know why defendant wants to unredact this. This, we have worked real hard to keep this out.
Yeah, we'll withdraw that one.
All right. Then we go to page 133, beginning at line 12, and it goes through 141.
Okay.
My notes reflect that this is a discussion regarding law enforcement officers and Kouri Wright taking all computers related to C&E and maybe some others, and Kouri having access to the garage and office at the Richins home. How does this qualify, provide context for Ms. Richins' other statements in the interview?
Just a minute. I'm trying to see where their redactions start and end on either side. So give me 1 second. Six. Three. So is everything after 141 redacted still on the, I haven't seen the newest version. Everything after 141 is redacted still.
No, there's some unredacted portions beginning at page 167. The statement before this redaction that we're discussing is the defendant's statements as it relates to life insurance. The statement after this redacted portion we're discussing is the defendant's statements as it relates to the trust. And the piece that we're redacting relates to collection of C&E computers, which in the state's view under 106 is not context to either the preceding or the subsequent statement.
133, line 12 to 140. That looks accurate based on my review, Ms. Nestor.
I think most of this has come in now, so I'm just making sure that there's nothing. Almost there. One more second.
Take your time.
It was quite a few pages. That's all come in, Your Honor. We don't need it anymore.
All right. So defendant's request to add pages 133, line 12 to 141 is withdrawn. Then we fast forward to pages 174 through 184. Here, Ms. Richins is talking about the party's joint account and the flow of money from C&E and her real estate business through various accounts.
Right.
The immediately preceding statement is regarding the trust. The immediately following colloquy seems to be about life insurance policies.
Yeah, just a minute. So this is 10 pages. I also think most of this has come in. If you can give me just a moment, Your Honor.
Sure.
There was no change in all that. There is no break at 141. The redactions continue until 1. There's no change.
I think that all came in, Your Honor. We'll withdraw that one.
All right. And then finally, page 213, line 25 through 215, line 6. This immediately follows a statement by Ms. Richins regarding Eric knowing about the HELOC and consulting a divorce attorney, and him knowing about that based upon statements made by his family members. I'm not sure. Forgive me, I misstated that. It immediately follows a statement by him about knowing about the HELOC. And then Ms. Richins talks about how he knew about that was because his family members told him, and then he went and consulted with a divorce attorney.
Right. I do think that's all one conversation, Your Honor, where they're talking about how he I gotta go back a little further. They're trying to say what they're accusing her of and how they changed I mean, that's all one conversation, I think. I stand on that
Tell
request.
me why Ms. Richins doesn't pivot away from what Eric knew to what his family members were doing to her. There seems to be two different topics here.
Well, I think this is all connected to the HELOC. I mean, Ms. Benson testified early on in this case that the HELOC was what precipitated the meeting with the divorce attorney. The divorce attorney has also testified to that.
right?
This is Kouri lumping all that together in one conversation with O'Driscoll. So I do think this all should come in context. I just think it's all connected to the beginning of the conversation where they're saying that he was unhappy about the HELOC and that he had been meeting with someone about a divorce and that Kouri was unaware of that and that she learned about that later from the family. So I think that's all connected. I would ask that that come back in.
Mr. Bloodworth.
Your Honor, the preceding statement, which is the statement the state seeks to isolate, is the defendant's statement regarding what she knew about the HELOC. In the redacted portion, she then pivots to divorce attorney discussion, which is in her statement separate and distinct from the HELOC discussion. It has come out in trial that the two are connected, but in this statement, it is a distinct statement through the course of this interview.
Just in terms of ending that, Kouri Richins. Yeah, I think it seems that Ms. Richins' sentence that begins on 213 line 22 doesn't actually end until 214 line 2. It looks like maybe she and Detective O'Driscoll talked over each other in that point. It would seem appropriate to end it there and then redact the rest. So just to unredact 213 line 25 through 214 line 3.
Agreeable.
Okay. That's the court's ruling, Ms. Nestor.
Understood.
So we're going to unredact page 213, line 25 through 214, line 3. Okay. I think that handles the parties' positions regarding the transcript of Detective O'Driscoll's interview with Ms. Richins. Mr. Bloodworth, anything else on that?
No, Your Honor.
Ms. Nestor?
No, sir.
Okay. So that brings us to the jail calls. This was originally filed as docket 1165 by the state. It's further characterized by docket 1555. We're just going to have to go through these one at a time. As a matter of mechanics, Mr. Bloodworth, these will come in through Detective O'Driscoll.
Yes, Your Honor, as a matter of mechanics, and I don't know at this point if we're going to introduce them all through Detective O'Driscoll on direct. In fact, trying to recall, there may be only one or two that I can pin down that we may want to address first, although I think that if we can, we should resolve the whole set of them today, because I can see how it would come up in either redirections and crosses that would could begin as early as today.
All right, let's go through them. So tab, well, I don't know if you have the same binder. Let's go 2-69T.
Your Honor.
And my main concern is on page 8, lines 6 through 18.
Sorry, Your Honor, I'm just pulling it up. Which one are you looking at? Can you give me the number again, sir?
2-69T.
Okay, got it. And what portion are we looking at?
Well, the court's concern, based upon the content of the unredacted portions that the state seeks to admit, is page 8,
Lines 9 and 10?
especially. Yeah. Although,
Oh, that's definitely part of it. Well, that's Carmen being in jail, right?
yeah,
No, she's not in here, meaning Summit County Jail.
Jail is she in because she's not here?
yeah.
Oh, well, she's not
The only
here.
way was Ms. Richins would know she's
Right.
not there is because
Right.
she's there.
Right.
So
Yes.
yeah, Your Honor, we can certainly redact line 9 and 10 there. We can even redact 11. I don't,
Yeah, if we
Just
can
to
do
be
9,
safe.
10, and 11. Yeah.
Yeah.
Okay. Ms. Nestor, what was defendant's objection to the remainder of this?
Hold on just a minute, Your Honor.
So Brittany, from 2-69T, we're redacting page 8, lines 9 through 11.
I think that was my objection to this one.
Okay,
Let me just make sure. I think that was it. I think that was the only problem I had with that one.
very good.
Wait, hold on. That's Carmen. Yeah, that's it, Your Honor. That was my objection.
Very good. Let's go to 2-71R. There's only 3 text messages sent from the jail.
Oh, I'm sorry, Your Honor. Oh, never mind. They redacted it. Okay, I apologize. Please continue.
2-71R. These are text messages sent from the jail system. The state seeks to admit 3, right?
yes, sir.
It's the ones from May 24 at 9:50, May 24 at 10:02, and May 24 at 10:03.
Correct.
Okay.
So we have a couple of objections to this one, Your Honor. It looks like they have made all the redactions that we requested that indicate it's jail related. So those have been resolved. However, this is a correspondence between Kouri and her brother. And the brother's asking her, did Eric ever talk about suicide?
Right.
And she's repeating things that Eric said to her, which would be hearsay. Also, I believe the brother's statements are hearsay.
Well, all of the non-Kouri Richins statements are going to be hearsay if they're accepted for the truth of the matter.
Right.
So that's
Well,
an
but
issue.
they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. She's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay. So that's our objection to this one. Also, we just don't see the relevance. There's no,
you don't see the relevance of whether Mr. Richins ever spoke about suicide.
I don't think either side is making the allegation that he intentionally killed himself. That's never been said by either side.
I think the state is seeking to prove affirmatively that he did not. So I think we can put relevance aside. It's certainly relevant.
Okay.
Mr. Bloodworth, talk to me about the hearsay. Put the brothers level aside. It's the truth of Eric's statements to Kouri as related by Kouri. Kouri's level, categorically not hearsay. It's the Eric Richins level. Let me pose a hypothetical to tease out the legal issue. It'd be one thing if, I guess what we're trying to tease out is whether this is evidence of whether Kouri ever heard Eric say it, versus whether Eric ever had suicidal ideations.
So I appreciate that distinction, Your Honor. She doesn't quote him, right? It's a generic, this is my impression of generally,
Of my husband.
right.
Well, respectfully, I disagree. He would always say things like, if anything ever happened to me, blah, blah, blah. I mean, if they want to redact everything after the word not suicide specifically, then my objection, apart from the relevance, which I stand by, but that would cure the hearsay problem of what he actually said. But they could leave in her answer not suicide specifically, because I don't think that relates to a particular statement. It actually refers to the absence of statements.
I think the opposite. That is what explains her statement, not suicide specifically.
Well, then it shouldn't.
And-
Then none of it should come in.
Right. The statement is, Kouri Richins' statement is not suicide specifically. The remainder of that particular text message is, in a sense, 106 completeness, because she is explaining her statement.
Why don't we just instruct the jury that they can't accept Ronnie or Eric's statements for the truth, but they can accept them for the effect they had upon Kouri Richins and let the whole statement in?
Correct, Your Honor. That's appropriate.
Because it's not being offered to show any effect on Kouri Richins. It's being offered to get in the fact that Eric made that statement to her. That's the whole reason this is coming in. And I stand by my objection, Your Honor.
And just to be clear, you don't want to admit the statement that Eric told her they'd be set for life if he died.
No.
Okay. All right.
That's like, no.
Yeah, I guess if the statement Eric made isn't true, what relevance does it have, Mr. Bloodworth?
It explains Kouri Richins' statement, not suicide specifically. It is the effect on Kouri Richins to make this, to respond to the question of, did Eric ever, whatever the question is, hold on. Did Eric ever talk about suicide? She says, not specifically, and then explains herself.
So
That's
is the
foundation for her statement. It shows what the effect of Eric's statements on her.
right. But as we tease this out, it seems that to the extent that the effect upon her was relevant, regardless of whether it was true, it was her understanding that she'd be set for life if he died, not whether or not he had suicidal ideations. Is that fairly stated?
Your Honor, the state thinks it's both, actually. It is the set for life if he died. It's certainly that, right? But it's also the suicidal ideation part, because evidence will come in that I think evidence is going to come in that she never believed. She said he would not commit suicide in other portions of.
Well, and at her level, that can come in, right?
Sure, but there's a foundation for that. Why do you believe that?
I think with respect to this particular text exchange, first of all, I don't understand why we need the third one. We work backwards from there. Why do we need her brother saying, just curious, someone threw out a scenario, made me think? That seems to be a throwaway.
Well, I guess it all depends on whether or not DJ testifies.
Forgive me.
That that statement could be used in impeachment of DJ Kouri if he were to testify.
Is this one of the things that's coming in through the state's case in chief or the rebuttal case? Or through cross? My apologies. as yet unclear.
So, yes, Your Honor, let me perhaps resolve, I think, the current tension.
Yeah.
If it comes in the state's case in chief, then I would agree that third statement we could redact. We may have a discussion down the road about unredacting it.
Understood. Okay. So focusing on the first two, I think the correct result here, let me state it and then let counsel ask for any clarification, is to admit the first two text messages with the following instruction to the jury, that they cannot consider Ronnie's statements for the truth of the matter only for the context that they had or the effect they had upon Ms. Richins as the listener. They cannot consider Ms. Richins relating what Eric Richins told her for the truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that that statement by Eric Richins had upon her on a going forward basis.
What, can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all. And
She
maybe
thought she would be set for life if he died. It provides a motive to kill him.
Okay.
Mr. Bloodworth, any clarification?
No, Your Honor.
Okay. Any other clarification, Ms. Nestor?
No, sir. We just would like a continuing objection to that one.
I don't know what you mean by that.
So I don't have to, when they admit it, I won't have to jump up. I just like,
And you don't, under
Okay.
Rule 103, have we discussed anything further on that?
no, sir.
Okay. Scott,
Yes, Your Honor.
would you initially redact the message from Ronnie at 5:24 at 10:03? Just curious. I watched something,
That's-
etc.
I think it's from DJ.
Oh, I'm sorry. You're right. That's from DJ. For now. And I can pause for a second if my description was inappropriate.
We're getting it. We're tracking it in the back as well.
No problem. Sounds good. Okay, moving on. That brings us to 272R. As I understand it, it's 5 text messages from 5/31/2023 at 7:14 to 5/31/2023 at 7:24. I think the relevant part of this, Mr. Bloodworth, is that Ms. Richins saying she hardly knew Hayden Jeffs. Is that the point of this?
Correct.
Okay. And so do we need anything after the 5:31 at 7:22 where she says that?
So you're referring to the last two of those texts?
Yeah.
We can redact those.
Okay.
Wait, I'm sorry. Which ones? I missed which ones you're talking about right then.
Another one wanting their 15 minutes of fame. Oh God, huh?
I would object to that coming out. I object to this whole thing coming in, but if it comes in, they should all be in.
All right. Tell me why you object.
I don't understand the relevance of this at all.
So we have testimony that's come out that Kouri Richins had a telephone conversation with Hayden Jeffs regarding the topic of fentanyl. Here she's saying she hardly knew him. It's probative of their relationship.
They don't talk about that at all in here, though, about any conversation that
But
she had with
she
him.
talks about hardly knowing him.
Your Honor, we just stand on a relevance objection.
Okay, anything else?
No.
Okay, this is relevant to Ms. Richins' knowledge of or disclaiming knowledge of Hayden Jeffs. And do you want the whole thing, Ms. Nestor?
Yes, I do.
All right, we'll leave it as is, Mr. Bloodworth.
Yes, sir.
Okay. All right, tab 7. Sorry, 273T and 274T and 275T. Mr. Bloodworth, Ms. Shervanek, I am genuinely confused by these in terms of this transaction in St. George and this other deed. And I read them 3 times. I really don't know what they're talking about.
So let me propose this as a way forward.
Yeah.
To date, nothing has come in where the state would use these. I can see a circumstance where the defendant's mother would testify that the state would want to use these texts in impeachment
Or the phone conversation.
or the phone
Right.
conversation.
Okay.
So maybe we can just put a pin in these till if and when that circumstance arises.
I appreciate that. Any objection, Ms. Nestor?
No, Your Honor.
Okay, very good. We will skip 73T, 74T, and 75T for now. Then we go to 2-76T. With respect to this one, the defendant objects to redacting lines 2 through 8 on page 7. Under Rule 106. In the court's view, Lisa making a comment about a corrupt police force is not required to be included under Rule 106. But Ms. Richins wondering if Detective O'Driscoll didn't relate part of his conversation with her to the prosecutor. That seems to provide context.
It wasn't the corrupt police force comment I'm interested in. It's Kouri's. So I don't have a problem with that staying redacted.
So I think if we just focus, Mr. Bloodworth, on page 7, lines 4 through 8.
I also, Your Honor, while he's looking at that, I did catch on page 7, line 19 and 20. I think that's Lisa reading the information, I'm guessing. And that's the hearsay the court's done an in limine ruling on page line 19 and 20 on page 7. That also, just that one little part needs to be redacted. He later told his friend he thought Kouri tried to poison him. That's been kept out.
Well, that part's come in a couple of times. I think it's the sentence before that's the problem. Because that's part of what the state has to prove, right?
Actually, both of those.
I
So-
think they both come in.
Forgive me, have we gotten the detail of
The only thing that's come
ate the
in.
sandwich, broke out in hives, had trouble breathing?
No.
That detail has come in, I think, in the context of, well, in Ali Staking's testimony about what they were joking about.
Yeah,
I think it's all-
certainly ate a sandwich. Had a reaction. Was she that specific? I genuinely can't remember.
No.
We can, hopefully somebody in the back scrambling right now
But
to
take a look.
get that portion of the transcript. I also think it's coming in a text message as well.
There's the June text message, right, where Ms. Richins is, I forget who the recipient of that text message is.
Chelsea Barney.
There you go. Is talking about, they're saying I gave him a sandwich on that day. And
Right, it's correct. It's the defendant saying, I was with him when he ate. I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
that's right. Okay.
The concern I have also is it says he later told his friend, which is Cody or Case, one of
Well,
those.
he doesn't say that. And we've already got testimony that there was a conversation in which he told a group of people that she tried to poison him.
Jokingly.
Well, whatever.
This is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
Yeah, I don't think that we know to draw that connection, but the jury wouldn't.
I don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
I am standing behind it. Let's take this one piece at a time. Mr. Bloodworth, line 7, can we please add in any objection adding back in lines 4 through 8?
Sorry, page 7,
Page
lines
7,
4
lines
through 8.
Yeah.
No objection to adding that back in.
Okay, so we will remove the redaction in 2-76T of page 7, line 4 through 8. Then, Ms. Nestor, what is defendant's request with respect to lines 16 through 20?
Your Honor, all we're asking is at Lisa Darden's statement, which starts on line 16. And then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. We're asking to redact that whole comment of Ms. Darden.
Mr. Bloodworth, the state's response.
Your Honor, I think the, just as some context here, Lisa Darden is reading from, I think it's the interrogatories in the civil case. That's why she uses the word question. The important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think the court can instruct around any any hearsay problem about considering it for the truth of the matter asserted.
Okay. Defendant's request to redact lines 16 through 20 of page 7 of 2-76T is respectfully denied because that information, that Eric ate a sandwich, that he broke out hives, had trouble breathing, later told his friend non-specifically who that is, that he thought Kouri tried to poison him, all of that has already come in through other sources of evidence. That will not introduce any new information to the jury if they were to fail to follow the court's instruction that they cannot consider the non-Kouri Richins part of these conversations for their truth.
Your Honor, can I just also, while we're just making the record, we would also ask that lines 9 through 13 be redacted on the same grounds. I understand your ruling, but I just want to make a proffer that we'd also want redacted. So they're saying they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with a supposed love note. I don't believe that has come in. I respectfully disagree. I don't think it's ever come in. He had trouble breathing. And I just want to make a record on that, but I understand your ruling.
Okay. Let's see. I think that handles 2-76T. Let's go to 2-77T. Defendant objects to redacting the following two sections. Line 20, page 21, lines 14 through 25. This just seems to be a self-serving statement by defendant that is not necessary to qualify, provide context for, or explain any of the other unredacted statements. Why is this necessary under Rule 106?
Page 21, lines 14 through 25.
Yeah.
Let me check and see when they. We don't need that. We'll withdraw that.
Okay, thank you. And then, same exhibit, 2-77T. Please go to page 25. Lines 2 through 16. I'm not sure why this is Rule 106 material either. It is almost entirely Ronald Darden statements with just Ms. Richins making non-substantively responsive comments.
Sit at the table. Sit here. Yeah. So, for example,
Okay, I don't need anything above line 14, but line 14 is the beginning of her sentence that starts on line 17.
Okay.
So we need 14, 15. I don't really care about 16. It doesn't, I think he's talking over her, but 14 and 15 is the beginning of the sentence that they start with 17.
And
I-
what's the problem with lines 17 through 19?
What page?
This is Kouri Richins' statement.
She's saying her mother was telling her, so it's triple hearsay. It's her mom telling her what her mom read about what other people said.
Okay, and then doesn't she go on to talk about that on the following pages?
I'm not sure what you're asking me.
If we don't include lines 17, 18, and 19, we don't know what she's talking about when she says stuff showing that I bought lunch at Mirror Lake, like I didn't make any fucking sandwiches. It's context for what she's talking about.
I don't
later.
think any of it should come in. I mean, it's all talking about a triple hearsay statement and she's addressing it.
It's her making comments about what did or didn't happen with respect to the sandwich on Valentine's Day.
It's
That's
her
relevant.
responding to what the triple hearsay statement is saying.
Well, that's fine, but the statements made by other people do not come in for the truth. Her statements are admissible as categorically non-hearsay.
So you're going to make an instruction on this one as well?
I'm making an instruction on all of them.
Okay,
That
I'm
they
sorry.
cannot consider the statements that are made by people other than Ms. Richins for the truth of the matter asserted.
So I'm sorry. I did not understand that you were suggesting that you're making one instruction for everything. I don't know how they're introducing these. I don't know
I
if they're
can
all.
make an instruction every single
That's
time.
what I'm asking.
Yeah, happy to.
Okay, that's.
Any other objections regarding this?
Your Honor, we don't think any of it should come in. We think it's all hearsay. We object to all of it.
You're going to have to be more specific. Do you believe that Ms. Richins' statements are hearsay?
Yes, because she is incorporating into her statements the hearsay statements that others are making about what happened in order to give her own explanation. So yes,
Any other objections?
no, sir.
Defendant's objection is overruled. Ms. Richins responding to questions posed to her by other hearsay speakers is categorically not hearsay. The court can instruct around the possibility that the jury might consider the statements of speakers who are not Ms. Richins accepting their statements for the truth of the matter. Mr. Bloodworth, anything further there?
No, Your Honor.
Okay, that handles 277T. All right, let's go to 278T. Mr. Bloodworth, take a look at page 11 with me, please.
So, Your Honor, maybe I can head some of this
Please.
off. So this, along with, I think it's 2-90, right? This all goes to recovery of the walk the dog letter, which is entangled with a whole lot of Kouri Richins' in jail. I have a proposal.
Why is recovery of the walk the dog letter going to be an issue that comes in before the jury? I've already ruled on any motions to suppress it.
I don't think it has to.
I'm so sorry. Which number are we looking at right now?
Currently, we're looking at 78T and 90D.
So at the outset, from the state's perspective, in introducing the walk the dog letter, how it was recovered, I don't know that that matters. But I can envision a scenario where, for example, defense the defendant has said that this 6-page walk the dog letter, it's been redacted down, but 6-page walk the dog letter was part of a 65-page fictional manuscript, and it was recovered from the middle or whatever of that manuscript, and the context of it, the context of the 6 pages is within the volume of a book. That is untrue, and we could prove that by proving how it was recovered.
Let's go in order of events, though. In terms of Jeff O'Driscoll testifying about the walk the dog letter.
Go ahead.
Go ahead,
Here's my proposal.
please.
I would like to show Jeff O'Driscoll a copy. Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
Any objection, counsel?
Rather than bringing in, so the idea would be he's not going to bring in 278T and
No, just we'll start there, and it will inform what we do with 78T and 90D.
So the way he just explained that answer, I don't know what I could object to.
Well, if you object to foundation, you're going to create a problem. So I just need to have what he's proposing is that question be not non-objectionable based on foundation by stipulation of the parties.
Well, I don't plan to object to that question because I don't want to get into the fact that her cell was rousted.
Right.
So, I mean, I'm certainly not going to open that door.
Okay. So if it comes in that way, as I understand it, there's no need for the state to use 2-78T or 290D in its case in chief. Is that accurate?
Correct.
Okay. Ms. Nestor, anything further there?
No, sir.
Okay. Okay, then can we go to 2-93T? I think this is Ms. Richins talking about speaking with Ms. Bramwell and Heber.
Just very briefly, Your Honor, I think they missed redacting the word jail call on the first page on this one. If we could just make sure they do that.
On page 2?
On page 1, the cover page, up at the, in the heading.
Oh, I don't think we're showing any of the cover pages of any of these, right?
I think they have the dates on them, so they may.
Yeah,
Okay.
Your Honor, we did miss that. We will fix that.
My apologies. Okay, very good. So jail call 1 will be redacted from the caption on page 1. Thank you. Help me out. What is the probative value of this one, Mr. Bloodworth? And is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer
Okay.
necessary.
Very good. 2-93T is moot. All right, 2-94T. Part of this is regarding the vacation booking statements. Part of this is Kouri Richins making statements regarding the vacation booking statements. And part of this is regarding the thing in Heber. Candidly, the statements or the back and forth regarding the quote unquote thing in Heber is pretty confusing. The first part, I think, is more clearly probative.
This one also, Your Honor, they missed jail call on the cover page. If we could just redact that.
Scott, page 1 of 2-94T in the caption, please redact jail call 2 from the caption.
Your Honor, at this point, because of the way the evidence came in, the state will withdraw this one as well. I can envision some corner cases where we might want to revisit it, but for now, let's just set it aside.
Very good. And then the video, 2-110, we don't need to offer that, right, Mr. Bloodworth?
Sorry, sir, I'm just bringing it up. Oh, no, so that went the same way as 278T and 290T.
Got it. Okay. Ms. Nestor, I think that resolves the state's docket 1165. Anything further on that,
No, sir.
Mr. Bloodworth?
No, sir, nothing on that. We recently identified 3 additional jail calls that we've redacted. We'll send those to the defense today. I don't anticipate introducing them today, but
Okay.
So we may have additional similar discussions.
Understood. And then, let's see. May I ask about the state's motion to admit redacted exhibits 8-57R through 8-63R? That is the state's designation of prior consistent statements by Carmen Lauber. May we talk mechanics for just a moment?
Yes, sir.
How are these coming in mechanically?
So, Your Honor, in questioning Jeff O'Driscoll today. I will ask him about conduct of the interview of Carmen Lauber. Ask him about the defense's question. You know, he was present when the defense questioned Carmen Lauber about certain statements. In context, do those, you know, are those statements, you know, fair? No. And then move to admit the various 57 through 60, whatever.
So I appreciate that the state has evidence through Jeff O'Driscoll and perhaps others that the arc of the interview, particularly the conduct by law enforcement officers or investigators and Ms. Lauber's responses thereto, are not the same as suggested by defense's cross of Ms. Lauber.
Right.
But you can elicit that evidence through Detective O'Driscoll's testimony. And to the extent you need to show that Carmen Lauber testified consistently with her direct versus the suggestions of what she said or what she said on cross, you can certainly do that.
Mhm.
My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements. Now, I understand context matters, but do we really need all of it, is my question.
Your Honor, the state tried to narrowly tailor the amount of information. I think,
And to be clear, I recognize that we went from 900 pages down to 100-ish.
correct.
So I understand that.
I think those 100 or so pages, narrowly tailored, are kind of the minimal amount to show the motive, Carmen Lauber's motive, that it was more, certainly there was a self-serving piece, but there was a lot more than a self-serving piece. And that she was not motivated by Detectives O'Driscoll and Maynard bullying her. I think the full expanded 900 pages show that the best. I think the 100 or so we culled to show it enough.
Do you have these as one kind of video clip that plays from interview to interview, or will you provide some signposts to the jury as you introduce them?
Your Honor, we don't intend to publish them. We intend to make a few points from them through Detective O'Driscoll's testimony, provide them to the jury, and in argument argue something like, you heard the defense cross-examine Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
Okay, I appreciate the efficiency of this. I have a genuine question as to whether I can send these transcripts back into the jury room when I'm not sending other transcripts of other testimony back into the jury room. I have some
Your Honor,
concern
it's
that
not testimony. It's evidence. It's an interview.
I mean, we'd have to go through the Crawford analysis to figure out if Ms. Lauber's statements were testimonial. Now, there's not a Crawford problem because she was on the stand.
Correct.
But whether these qualify as testimony with respect to the concern that providing transcripts of certain testimony would give that certain testimony undue weight when transcripts of other testimony are not provided, That I have a genuine question about. So I'm not suggesting that you can't publish.
Sure.
I'm asking whether you have to publish but not admit. But she
You're-
was in custody. She was being questioned by law enforcement officers. I think there's at least a reasonable question as to whether this would qualify as testimonial and quote unquote.
I think two things, Your Honor. In some measure, that's why the state moved to admit the entire shebang. But I appreciate the need for efficiency.
Right.
The second thought I have is, to the extent that the defense wants to further cross-examine Carmen Labra on these, or Detective O'Driscoll or Detective Maynard, they're here. We can all recall them easily.
I agree. Yeah, no, I agree with all of that. It really comes back to the issue of whether these transcripts go into the jury room. Publishing, you're right. You have the right to publish them to the extent you want to. I am not persuaded sitting here right now that they go into the jury room. So we don't have to necessarily reach agreement on that piece right now, but how do you want to proceed with Detective O'Driscoll on recognizing that they may not go into the jury room?
Your Honor, that would alter the state's direct of Detective O'Driscoll, because we would end up publishing 100 pages of transcripts.
You have him as video or audio though too, right?
Well, right now, we only have the transcript. We were waiting, video editing is long and expensive.
I see.
And so we were waiting to nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did,
Ms. Shermack is saying no.
it's just, it's the video file's the audio file.
I see. Okay.
It's one.
I see.
So there's no distinction in terms of editing time between a video and an audio file.
All right, pause there for a moment. Maybe I may be taking on more than I need to. Ms. Lewis, what's the defendant's view of this?
Your Honor, I mean, we object to these coming in this way. I think that
When you say this way, what do you mean?
by publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions about what he said. They can't ask him questions about what she said. That'd be hearsay.
I understand, but the problem that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe is a Crawford problem.
Well, hold on. I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or undue influence.
I understand.
So any objection under that rule?
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked you a yes or no question. Would you start there for me?
Could we recall her? Yes, that is something that could be possibly done. I don't imagine what world a defense would do that. But
And correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought to,
During cross.
and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting in an entire transcript.
Well, you
And-
can do it, for example, by admitting prior consistent statements. And so I just need you to stay focused on that rule for a moment. I know I'm interrupting you.
Sure.
I don't understand how you think they were supposed to admit prior consistent statements?
through testimony.
That's not a prior consistent statement. The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction, or there's a charge of recent fabrication or undue influence. Then you have the prior statement come in as substantive evidence.
Only while she's on the stand. They didn't even attempt to question her about whether or not to pull out these portions to show, oh, look at, you weren't unduly influenced. Look at, you said this, you said this. Is that correct? Is that correct? That's how you would normally see this done. Then I could have cross-examined her. And I also want to point out that they have taken very small portions of this that leave out the portions of the interview where she is being influenced by statements of law enforcement. This makes it look like, I mean, they've cherry-picked what they want. And for example, I want to pull out the May 10th interview. I don't even understand why this would be coming in. All they've pulled out is a conversation between Ms. Whistler and Ms. Lauber that Ms. Lauber is supposed to testify before the grand jury. That's going to open up a whole door of speculation and what happened. I don't see how that has anything to do with what we're even talking about. And as I go through the transcripts, it's very much just what the state wants the jury to hear. I mean, if we're going to do this, which I think is completely inappropriate, this is a Crawford problem. This should have been brought in through testimony when Carmen Lauber was on the stand, so she could have been cross-examined. They can bring in what they want through Detective O'Driscoll, because we still have an opportunity to cross-examine him. But to just send back portions of a transcript that we've not been allowed to cross-examine on, that point out to the jury just what they want the jury to hear, is inappropriate.
And I apologize, you're jumping around a little bit. So put aside sending transcripts back. I have concerns about that. Do you have any law for the proposition that prior consistent statements can only come in through the witness that makes the statement?
Well, I would point to a case. Let me pull it up again. I had it. Just give me a moment. I can't find it now. One moment, please.
Yep.
It's 366 P3rd 867, State of Utah in the interest of JC.
I'm sorry, would you give me the site one more time?
366 P3rd 867. And I direct the court to footnote 8.
Okay. All right, so I understand your objection there. Tell me why you think it's a Crawford problem. You had the opportunity to cross-examine Ms. Lauber. You did cross-examine Ms. Lauber. You used part of these interviews to cross-examine her, to challenge her on whether she just asked the law enforcement officers, investigators, just write her statement for her. I don't understand what a lack of confrontation Ms. Richins has had here.
Because what is happening here is now they are basically crafting testimony on her behalf. They should have asked her these questions. I haven't had an opportunity to cross-examine her on what they now want to bring in. They should have brought it in through direct, and instead, which I get was difficult with her. You know, she said she didn't remember anything. Instead of doing the hard work to try and ask her questions, they just want to put it all in, and they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it without putting in the whole story or giving me a chance to go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
And remind me, you objected to the addition of any part of the transcript at the time they offered it,
For the
correct?
same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said, okay.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And
Because
so how do you see the rule regarding prior consistent statements working?
they need to get it through her. They could have put on
But
prior
you
consistent
s-
statements through her.
I
And then
really
I-
don't understand. You're saying that prior consistent statements never come in. You only can ask questions. Please help me understand.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts of
Well, no,
former-
be fair to how the rule works. Somebody testifies on cross-examination, defendant makes a charge of recent fabrication, and then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. I hear you saying, no, they cannot offer the prior statements. They can only ask more questions.
They can offer them through the witness. They can say, is this your statement? And what if she says, I don't remember that? Okay, then they can refresh. What if she says, I don't remember that? Well, then it doesn't come in.
Okay, I think that's where maybe you and I differ on the way the rule works. Do you have any citation for law that says, unless the witness remembers, these don't come in?
Well, off the top of my head, I'd have to spend some time, but I would look at Rule 613 of the Utah Rules of Evidence that talks about this talks about prior inconsistent statements, but after the witness is given an opportunity to explain or deny the statement, an adverse party is given the opportunity to examine the witness about it. We don't know what she would have said. We don't know if she would have said, she may have very well said, no, I didn't feel influenced at all. That's fine. They could have asked her that question. Then I could have cross-examined her or recrossed her to say, well, what about this? What about this? What about this? Now I'm denied any opportunity to do that by just putting in statements. And I really don't know what else to say. I do think as I look through the transcripts, they have only picked things that they want in that we don't know that Carmen Lauber would have agreed to. But had they wanted to put them in through her, at least then I could have questioned her I could have questioned her. I could have said, so this didn't make you feel pressured. So that didn't make you feel pressured. So they said this, so that made it, so you felt you were telling, I don't know. You see where I'm getting. And I don't have any opportunity to do that in this way. They can ask Detective O'Driscoll questions. We can cross-examine Detective O'Driscoll, and the jury can make a determination of that. But by cherry-picking statements that they wanted Carmen Lauber to testify to, but didn't ask her, I think that's error.
It's not the cherry picking, it's the root, right?
It is.
I mean, you cherry picked statements too. Everybody cherry picks
Right,
statements.
and they could have done it on redirect, and they chose not to.
So again, it's the root, not the cherry picking, right? If she were
Well,
on
yes,
the stand,
yes,
the
if-
cherry
yes,
picking would not be a
absolutely.
problem.
They could have, because then I could have gone back and pulled out other statements.
I think we're agreeing. Okay. All right. All right. I take your argument seriously. Mr. Bloodworth, I'm going to have to take a look at this real quick. I understand this to be a threshold issue with respect to Detective O'Driscoll. Is that right?
Yes, Your Honor.
Okay. Anything further at this moment?
Your Honor, I'm pausing. Can we have 5 minutes?
Of course. Just so I'm clear, we'll take 5 minutes for you to confer with your team, and then you'll tell me whether this is a threshold issue that I need to decide before Detective O'Driscoll takes his.
Correct, Your Honor. It is now. That may change.
Okay, understood. We'll take a 5-minute recess. Thank you. Mr. Bloodworth, before you weigh in, I need to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B, it is categorically not hearsay and he can relate it. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P3rd 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in. And the Utah Supreme Court expressly declined to reach the issue. They did not rule that they must come in through the declarant. So, as I sit here today, there is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination. Indeed, it is defendant's cross-examination of Ms. Lauber that creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that. There is not a Crawford problem here. I also have another thought regarding the transcripts going back, if you want to discuss that.
So maybe we can get the court's thought and then I can incorporate that into the state's position.
Sure. Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence on the basis that Rule 17K of their Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury, because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury, end quote. Now, typically that's guns, knives, poison, explosives. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review. But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance. It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just that it's the defense strategic choice. And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Cochadimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the route anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's what's time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process. Under the Utah State Constitution and the federal Constitution, she is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it
Which
all go
specific
back.
part, you gotta be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. Stay away from going back. Let's just stay on publishing. So I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand it, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings and then allow counsel to make whatever arguments they want to make about, you should go back and listen to this part because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No,
So
our
you're saying
objection
publish.
stands.
Let me start again. Imagine that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that, then it should all go back. Or,
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
It's showing up on the screen.
see, my hesitation is just efficiency. Like I said, it's over 7 hours worth of video, but if that's how the court wants to do it, then yes.
No. That's what I'm asking you. So imagine, here, I'll just make a ruling. I have considered carefully the authorities cited by defendant and the state. I've looked at the text of Rule 801. Ruling as a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath, was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So Ms. Lewis, take it from there. Some of her prior consistent statements as designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I
We
guess-
could just publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth, out of an abundance of caution, is saying prophylactically to prevent any appellate issue there, we would just publish. But if the defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them. You could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R. I think beyond I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview I don't think it's productive. I think it's a waste of the jury's time.
Okay. Ms. Liz.
We object to it all going back. It's the same problem. The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
Because there are, I mean, I already made my issue or raised the issue about the May 10th.
We'll get
Transcript.
there specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part, but there's a lot that's being left out, and a lot what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
You haven't, but that's okay. You can certainly have access to this witness.
Well, I think we've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because, I mean, all of them.
Okay. All right. That it's hard to rule on because it can't be all.
Why not?
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know. And now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would, I mean, we want all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that, but
Okay. So, Mr. Bloodworth, as for today, how does the state propose to proceed?
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, I don't know, 45 minutes into his argument before this will become an issue.
Okay.
My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D1B.
Fair.
So, all right. The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does. And that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Ms. Lewis.
Yes, Your Honor, we actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning. request for a 2-day continuance is denied.
All right, a 1-day continuance then.
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
Mr. Bloodworth.
Your Honor, the state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
All right. And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yes.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes.
That is so slow. There's just no way this is going to work. There's no way we can edit the video.
I'm not tracking, Your Honor.
Each of these transcripts corresponds to a video of an interview, correct?
Correct.
It would seem that watching and listening to the video is more efficient than reading the transcript.
Oh, 100%, Your Honor. Based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it.
Okay.
Let's just cut to that chase.
All right. Folks, give me 5 minutes. Actually, just give me till 11. Okay. We're in recess. back on the record in 231-500-139. Counsel for the state and for defendant are present. Defendant is present. Ms. Lewis, the defendant asked for a one-day continuance to allow time for defendant to, on the one hand, review the designations made by the state to determine whether there are some over designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video so that when we're publishing a video, not just pages of a transcript. Let's work backwards from there.
Mm-hmm.
How long is that process? And if you need to take a moment, step out and tell your video editor to press pause, I'd understand.
So the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out.
Right.
Hard to say. 4 hours?
Okay. All right. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to come back midday tomorrow.
So we can do that, assuming was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis.
We're just discussing, I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in 12-point font.
But
The Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designating, you're just taking stuff out of those. So it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I don't understand. what
Well,
you mean.
if, for example, there's 200 pages of interview with Jeff O'Driscoll the first time, and the state's just trying to put in 20 from the beginning, you don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not, they're just portions that are prior consistent statements. And so it's, did they over designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify, provide context, or explain?
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on reason motive to fabricate.
Yeah, that is the same. That's both. That's the prior consistent statement rule.
Yeah, it's. I think there were 2 separate things in 802D1, but maybe we're saying the same.
801D1B.
I mean 801D1. Yeah.
Is consistent with the declarant's testimony and is offered to rebut. So
Right.
it's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon a lack of memory.
Nothing in A.
I think we see it the same way.
Okay.
We have till 11 p.m.
No, I need time to read it. The state needs time to read it. This is possible. I want to make sure that we have a common understanding of what you'd be permitted to do under 801D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over designation by the state under the bounds of 801D1B, I need to know. And if, in defendant's view, there's a Rule 106 inclusion that's required before or after these designations, I need to know.
Understood.
Okay. So 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, what I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
Okay. Now, in terms of how to proceed for the remainder of today, do you want to put Contradimus on and get him done, or do you want to break now?
Your Honor, if we can call him, he's 10 minutes.
Okay. Any objection, Ms. Lewis?
Eating into our time.
All right.
Oh, okay.
Well, he's only gonna be 10 minutes.
Yeah.
All right.
We're taking out.
Okay. Got it. And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that sound reasonable?
Yes, sir.
Okay, very good. Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Have a seat as you come in. Thank you. Have a seat. Thank you. Ladies and gentlemen of the jury, I greatly appreciate your patience while we work through some legal issues. We will proceed with a witness from the state, and then I have some scheduling notes for you. Mr. Bloodworth. Oh, Ms. Sherman, my apologies.
No problem, Your Honor. Chris Kochademus, please.
If you step in front of Brady.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Have a seat. Good morning.
Good morning.
Although the jury knows who you are, I'm going to have you state your name and spell your last name for the
Yes,
record, please.
It's Chris Kotridimus, Kotridimus.
Now, we brought you back to talk about a couple specific issues. We know from your prior testimony that when you reviewed data from Eric Richins' phone, specifically for February 14th, 2022,
Yes,
you looked at the Verizon call records.
correct.
Those included text messages.
They did.
And that's the raw data that we talked about throughout your testimony.
Yes.
Is that right? And tell the jury, for an outgoing message from Eric Richins, how would Verizon list that time zone in their record, in their call record, that raw data?
Well, it would depend on what type of message it was. For an SMS text, which is just a normal type text, it would route it through their normal server. It would be in local time. For MMS, that message has to be routed through a server. And so they use the server to route that call. And it would have a timestamp for the location of the server, not necessarily the device.
So when you looked at those records, the outgoing messages for Eric Richins' phone in the Verizon records, what time was reported for an MMS outgoing from Eric Richins' phone?
So there was an outgoing, in the record, there was an outgoing MMS at 12:23 p.m.
Would that be 12:23 p.m. in Utah?
No,
So what would the time of that outgoing message be for us in Utah?
we're 2 hours behind. So it would be 10:23 a.m.
Scott, if we could put up 3-14D, please. This was previously admitted in Mr. Kochademus' testimony. We can publish it to the jury.
Okay, there you go.
So we entered this exhibit through your testimony last time, and we talked about this gap in activity from Eric Richins' phone. And so what you've just described conforms with the raw data. Is that right?
Yes.
And describe it again now that the jury can see the time frame we're talking about. If a call record or a text message MMS showed outgoing from Eric Richins' phone at 12:23 in the raw data, you confirmed that that would have been 10:23 in Utah.
Correct.
How did you verify that?
So one, just the knowledge and experience of knowing that that's how Verizon routes MMS messages. They use an Eastern time zone, which is consistent with their headquarters location. So to verify that, for time zones are very critical for analysts, obviously. So what you would do is, if you have a source to look at the original text, and in this case we do, which would be Eric Richins' cell, his phone extraction, his cell download, I would expect to see, based on the time difference, an outgoing MMS text at 10:23 a.m. versus 12:23 p.m. And I did find that there was an outgoing message at 10:23 a.m., an MMS message to that number, and it was a photo.
So essentially, through your analysis and changing the time zones as necessary, this exhibit is still accurate.
Yes.
Scott, if you could put up 3-39D, page 5, please, for the witness. This has previously been admitted. And you can publish it as well. And you can blow up one of those messages or. So now that we're talking about time zones, describe for the jury how we get to the times that are listed in all of these text bubbles. And so that the jury knows, all of the messages that we have entered have these timestamps on them.
They do, yes.
And how do we get to the time that is on there?
Okay, time zone issue again. Okay, so phone extractions from software are provided, those readable files are provided in UTC 0. So to determine local time of when that activity on that device happened at the local time, you have to adjust. So Utah is -7 UTC during normal standard time. It is -6 UTC in daylight savings. So we just switched on Sunday. So now everything until November, when we switch back again, will be -6. So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
So for each of the messages that the state submitted in this case, they have been adjusted to local time.
Yes,
Okay, those are all my questions.
sure, thanks.
Mr. Ramos? No questions. Okay. Sir, you can step down. Thank you.
Thank you, sir.
Council will proceed with the scheduling notes, correct?
Yes, Your Honor.
Ms. Lewis?
Yes.
All right. Ladies and gentlemen, I appreciate your patience this morning. We've been working very hard on some legal issues that will materially increase the efficiency of the presentation of evidence going forward. I know it's hard for you to know that, not being in the courtroom. I'm just asking you to take my word for it. We have more work in that regard to do. Rather than have you sit here while we do it, we're going to send you home for the day and not ask you to return until 1 p.m. tomorrow. So we will recess until 1 p.m. tomorrow. As always, during this period of recess, please do not speak about the case with anyone. Do not allow anyone to speak about it with you. Please do not watch, listen, or read anything about the case. Please do not do any research of any kind. I greatly appreciate your patience. Travel safely. 1 p.m. tomorrow. Please rise for the jury. All right, folks, have a seat. Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
No, sir.
Mr. Ramos? Okay. 8:30 tomorrow morning. Please travel safe. We'll be in recess. Thank you.